Oh, sorry.
My lords, 20 minutes of facts. And then, Deutsche Bank. We've looked at the findings regarding the transaction and the definition of transaction for the purposes of identifying the scope of their services. We might look now at what the tribunal finds by way of findings as to what was procured for the payment under the terms of that contract and what use was made of it. So, if we could start, please, at paragraph 90 of the FTT decision. Forgive me, page 90. Paragraph 71. We've looked at this. That an important part of Deutsche Bank's role was to evaluate the options available to Oxio. A strategic decision had been taken, but it was not clear what appetite there was. There was even the possibility the business would prove unsellable. 72. Another major part of Deutsche Bank's engagement was to identify possible buyers and evaluate the level of interest they might have in different parts of Oxio's business. In 2009, they produced a document, Project Erasmus, which considered the bar universe of energy companies who might want to buy or enter into an asset swap. A number of similar documents were produced in the course of the transaction as the range of potential buyers narrowed and other options, such as a sale to private equity investors, were considered. Paragraph 337. Its main roles were to advise on strategy and tactics in relation to structuring the transaction. Investor presentation, it's involved preparing marketing materials, identifying potential purchasers and making approaches to them, pricing. It also assisted in managing the evolution of the transaction and assisting with the due diligence process. 338. The options for structuring the transactions were wider than in the normal case because of the problems with the Oxio business. But it was an important part of Deutsche Bank's role to advise on those options and also the tactics of how they might be achieved. They advised on bilateral negotiations versus an auction approach and continued to look at a possible auction process and or other suitable buyers even after the negotiations with Aneco began in earnest because the bilateral discussions could have failed at any point. Indeed, this process continued after the 22nd of February 2011. It was Deutsche Bank which evaluated the potential purchasers and with Centrica's approval approached them to discuss Oxio. Paragraph 340. In summary, their advice was directed to the how to get the most value out of the Oxio business. Its advice informed Centrica as to the options available to them and assisted the company in deciding how best to divest Oxio and whether to enter into that particular transaction with Aneco. Paragraph 425. Considering the Regent Oil type of cases, the effect of the advice which Centrica obtained was not to bring about a disposal of the Oxio businesses, but to inform the management decisions about how best to do so. Paragraph 426. In the case of Deutsche Bank and PwC at least, the payments were made for services, that is, advice, and the advice was to be used to enable COHL to make decisions about its investment in Oxio. In the case of Deutsche Bank, that was strategic advice about the options for disposing of this difficult asset and assistance in finding a purchaser who would be prepared to make an adequate offer for at least some aspects of the Oxio business. In my view, the cost of such advice and assistance were part of the ongoing management expenses of COHL, as it enabled the company to make decisions about how it might realise value from its investments in Oxio. Now, yesterday, in the course of Malone and Friends submissions, the linchpin of his factual case in relation to Deutsche Bank and PwC, when we get into capital or revenue, departs from the following submission, which, to my mind, is with respect an Edwards and Bairstow challenge that is not made out on the basis of the material before the findings of the tribunal. What my learned friend said was this, looking at this paragraph in 426. In the case of Deutsche Bank and PwC at least, the payments were made for services, that is, advice, and the advice was to be used to enable Cole to make decisions about its investment in Oxio. And the submission advanced is this. And we would say that's simply a mischaracterization of the findings they've already made as to what Deutsche Bank and PwC were actually doing in return for the fees they were paid. And what happens then is the submissions that are advanced as to what the nature of this expenditure were in the context of all the discussion with Strickland Regent Oil, etc., that comes later. Now, in my submission, as I'll come on to in due course, when it comes to the law on that, in the first part, we say that's not the right test, but even if it is, we succeed. But when it comes to the factual premise of my learned friend's submissions, it departs from a premise which is not open to my learned friend, because he has not sought squarely to challenge that finding on an Edwards and Bairstow basis, and indeed, nor could he, which is why I've laboriously taken the tribunal through the findings as to what was secured from Deutsche Bank.
I follow you say that he's not entitled to say that there was a mischaracterization. I'm afraid I've forgotten exactly what he said the mischaracterization was.
I'm so sorry about this. Let me give you the reference. It's page 159.
This is the transcript.
The transcript of yesterday,
yeah.
Lines 16 to 19. There are also a number of other references that are made. It's not a criticism of my learned friend, it's just, with the greatest of respect to my learned friend's case, one has to proceed from the findings of fact that were made by the FTT. And if those are not, if those are unacceptable to them, then they should have been challenged on an Edwards and Bairstow basis.
And I see that point. It's simply I've forgotten what it is.
Oh, what he said.
Hewitt said was a mischaracterization.
So what is said here? So what is said here is the finding at paragraph 426 that I've just taken
yes.
you. The tribunal say, in the case of Deutsche Bank and PwC at least, the payments were made for services, that is, advice, and the advice was to be used to enable Cole to make decisions about its investment in Oxio. And what my learned friend says in relation to that is, that's simply a mischaracterization of the findings they've already made. And so then we go into an analysis of the extent to which the category of expenditure here in question falls within those capital or income cases. But it starts from the wrong place, because what those cases do not talk about is advice that informs managerial decision-making on these things. And I'll make that good when we come to look at the actual expenditure in ECC Watkis and also the cases from this morning.
One has to read 426 as a whole. I mean, the second sentence does focus on the advice being strategic advice on the options for disposing of this difficult asset. So that was the umbrella heading under which the advice was given.
Well, my lord, I'm not sure I follow. I mean, I don't deny that. But the point that I'm making is that whether or not putting the word strategic in front of this or otherwise doesn't add anything to it.
Well, it was disposing I was really focusing on rather than strategic. And it was all directed to getting rid of Oxio.
But it was advice, my lord, as that informed its decision as to whether to do so or whether not to do so, and if so, how to do so.
I quite see how all this feeds into your case on the expenses of management, but not at the moment clear as to how it's going to help us on the capital issue.
I'll make that. I promise I will make that in due course. But at the moment, I'm still. It does impact upon that as well, my lord.
Okay.
But the basic point I'm making at the moment is that the submission that's advanced by my learned friend was unfair on the tribunal, because it was perfectly entitled to identify that what was being obtained here was advice. There are then a large number of findings that I might have needed to take the tribunal, the court to, regarding the fee structure. I'm not proposing to do that because I think, in a sense, we've already looked at that, unless the court would like me to do so. If I may turn now to PwC. This starts on page 93, paragraph 94. Where the tribunal finds identifies the engagement letter. 95. The main service to be provided by PwC was the preparation of a report, the purpose of which is to assist a potential purchaser in its due diligence with a view to buying the business. That is, they were to prepare a vendor due diligence report. As Mr. McCourt indicated, this was not uncommon, but not standard. The VDD could be made available to potential purchasers, and PwC would discuss the report with them. At a later stage, PwC might assume a duty of care to the preferred bidder. But we then need to look at what that report actually did, what use it served. Paragraph 96, Centrica would arrange for PwC to have full access to Oxio's senior management, its financial records and its operations. The letter recognises that the report may provide you with information which assists you in forming or refining your view of the business and in preparing to negotiate a sale. But it's clear that PwC is not providing financial advice to Centrica or acting as its advocate to help them sell the business. PwC is acting as an independent accountant, producing a due diligence report for use by a purchaser. There's then a discussion of the nature of the report, and if one turns, we're going to come back to these paragraphs, if one could keep one's finger in it and turn these to paragraph 346, there's a little bit more on what this report says. Although PwC expressly stated it was not advising Centrica, its engagement letter acknowledged that the report may provide you with information which assists you in forming or refining your view of the business and in preparing to negotiate a sale. So the VDD report was capable of serving a dual purpose, helping the management of Centrica make decisions about a sale, as well as being used in the sale itself. As the authorities confirm, there is no wholly and exclusively test for expenses of management and advice, which has advice which has a duality of purpose can still qualify for deduction. Back to 98, if we may. The matters to be covered in the report were set out in an appendix and included business overview, business operations, including marketing, customer acquisition and retention and costs, accounting policies, historical trading performance, historical cash flows, historical assets and liabilities, current trading performance, projections, accounting records and management information systems, internal controls, management and employees and taxation. So it would be a very thorough review of the business. Paragraph 99, this point I think we looked at this morning, PwC's fees would be based on the time spent in producing the report, payable whether or not the transaction proceeded. Paragraph 100, Mr. McCourt indicated that a VDD report was more likely to be commissioned where there were difficulties in the business, as here. As they began to get into the transaction, it became apparent that the Oxio business had some problems and the financial information was confusing. It was felt that a VDD report would help to analyse what had happened. Although VDD is primarily for the benefit of a prospective purchaser, Mr. McCord said that in this case it helped Centrica to understand what was going on in the business and also decide how to proceed. Should they carry on with the sale now or stop and try to resolve the issues before attempting to sell Oxio? It informed Centrica's thinking and provided insight into the problems. Paragraph 95. Sorry, 183.
Sorry, 183.
103, I'm afraid, sorry. As PwC began their work, the scale of the problems emerged. As a result, they made a site visit to Oxio's headquarters on the 8th of July 2010.
But you've read this, actually.
But in a different context.
All right.
I produced a report for Centrica called the Project Erasmus Deep Dive. The purpose of the report was to enable Centrica to understand just how bad the problems were. and to inform their decisions about the options available in the context of the sale, and indeed whether the problems were so bad that the business was unsellable. The report was sent to Centrica's M&A team and board members. Executive summary noted, deep-rooted process and controls is exposed with a significant effort required to address weaknesses in advance of a sale process. The report went on to identify the issues, suggest actions within a time frame, and whether the actions were to be completed pre-sale or post-sale. Para 105, the final VDD report was produced on the 20th of January 2011. It provided a detailed analysis of the business and financial affairs of the Oxio Group. Although produced primarily for the prospective purchasers, it also benefited the board of PLC as it gave an insight into the problems, including the management weaknesses, as the Oxio management were unlikely to have identified themselves, and help them understand what action needed to be taken. 347. In this case, the VDD report did indeed assist Centrica to understand the business. As a result of the problems revealed when PwC began its work, it prepared a deep dive report for Centrica, which provided information about the nature and extent of the problems with the Oxio business, which informed Centrica's decisions about the options available for a sale transaction. 348, the VDD report, although prepared for a prospective purchase, did, along with the deep dive report, assist Centrica with its decision-making process, and I find that PwC's fees were also expenses of management. 426. In the case of Deutsche Bank and PwC at least, we've looked at this, I'm reminded, payments were made for services, that is the advice, this is the point we just looked at. But 427, the PwC VDD report, and in particular the deep dive, was advice which gave the management of coal an insight into the nature and extent of the problems in the Oxio business, and informed the decisions about how to deal with its investment. And again, back to the point we looked at earlier with Deutsche Bank in 425. Considering the Regent Royal type of cases, the effect of the advice which Centrica obtained was not to bring about the disposal of the Oxio businesses, but to inform the management decisions about how best to do so. So those are the findings against which the committee reached its decision. I was not proposing to do the same exercise for the De Brauw expenses, for the obvious reason that that is the subject of a remitter. So, Your Lordships, I should just clarify, I think my learned friend may have said yesterday that the remitter was on the basis as to whether or not these were capital. I think actually the remitter was for the FTT to decide whether or not the expenses were expenses of management. But it's as long as it is short. In any event, I don't think I need to take the Court of Appeal to them today. If you'd like me to do so. I wonder if I may just quickly whittle through some very swift references to the assertions of fact that were made by my learned friend yesterday, and give you, I don't need to take you through them all, the references which demonstrate that the assertion of fact was not safe, if I may. Day 1, page 92, lines 6 to 13.
So, page
92, lines 6 to 13.
Thank you.
It makes a difference that they were deciding between a number of different disposals, all of which were capital disposal. The tribunal makes clear that among all the options on the table was the possibility that there be no disposal at all. And you can get that from the FTT decision at 121, 218, 104. Sorry, my lord. FTT decision,
Yep.
paragraphs 121,
Yep.
218, 104, 71, and 327. Then the assertion was made by my learned friend on page 94, lines 13 to 15. As follows: I think the issue of whether to sell at all did arise during it because they were finding difficulties, but I would say that's pretty typical of a sales process. The FTT, however, found clearly that this was very far from a typical sales process. See paragraphs 71, 121, and 326. Then on page 95, lines 15 to 22, what I think they describe as the heavy lifting, if you remember, which is why they engaged Deutsche Bank, because they didn't have what they described as the bandwidth. They didn't have the resources to do these things. So it was quite plainly not advice primarily. That wasn't what they were being paid for. They were being paid for all the work they did. But in my submission, the findings of the FTT are completely inconsistent with that. What the FTT find is that they were hired because they could provide the best advice. Paragraph 59 of the FTT decision. Paragraph 71. Paragraph 337. Paragraph 426. We've seen paragraph 423, paragraph 71, paragraph 69, which we looked at yesterday. That's the point that's made, that even when transactions did not proceed, Centrica would sometimes pay fees if the advice had been particularly useful to them. I hasten to add, I don't mean this with any criticism of my learned friend. It's just that when it comes to identifying what the expenses are on, in my submission, as I've said, HMRC's case departs from the wrong place. At page 108 yesterday, lines 12 to 18. Commercially, the onerous asset was the business of Oxio, because when we look at the findings of fact, we'll see that it was draining cash from Centrica. They were continually having to put in money because the business was, operating badly. And that was what they were disposing of commercially. They were disposing of the business. But we've been through the findings of fact. And actually, that demonstrates that the options included not disposing of the business, but either improving it or winding it down. See paragraphs 327 and 218 of the decision.
I'm sorry, which paragraph?
Sorry, my lord. 327 and 218.
Thank you.
Paragraph, page 137, lines 7 to 10. You can see specifically what Deutsche Bank agreed to do, and if you look up the list, they're all directly in relation to the transaction. I've made my submissions regarding the width of what's covered by a transaction in this context, but I was anxious. The court has in mind that the concept of what's meant by a transaction in this is not linked to that which ultimately happened. And in each case, each of those three different limbs of what's described as a transaction by Deutsche Bank is used to deal with three different parts of the engagement, each of which involves the engagement as a financial advisor or exclusive financial advisor in relation to strategic alternatives. Probably enough of that. So, just to finish on general expenses of management, and I've covered quite a lot of this in the course of what we've said already this morning. But in HMRC's written case, and I think as developed by my learned friend, they identify the core of what is said to be the flawed analysis of the FTT. And remember that for these purposes, if they can't demonstrate an error of law in the test, then that's the end of the matter on expenses of management. The flaw that's identified at the heart of the analysis is that which I think is said to be at paragraph 329. And the court looked at that this morning, namely those four component parts of the point at which managerial decision-making will turn into something which is inextricably linked to the machinery of sale. We submit that when the criticism was advanced that what the FTT was doing was, as it were, identifying a date and then artificially seeking to allocate expenditure to one or other side of the line. That's not what the FTT are with respect doing, for the reasons I advanced to Lord Justice Singh this morning. And I would go further in relation to that. What the FTT is doing is identifying that the quality or nature of the advice and expenditure that was being incurred after the point in time at which an identified purchaser and transaction had been reached was different to that which was going on previously. To which I add that the decision of the FTT has to be read in the context in which it was pursued before it. And HMRC's case, and as I understand it remains to be the case, on management expenses, is that the fees in issue were, as they put it, simply implementation expenditure. And I've made my point regarding that concertina's what Sun Life says about it. And they say that the expenses in that case were simply the expenses of implementing a decision that those managing the company had reached to sell the asset. But we say that in these circumstances, the June 2009 decision in principle was an enormously long way from the type of final decision that was never reached in Camas and identified by Lord Justice Carnworth in paragraph 32 of his judgment. It doesn't have any of the ingredients that would lead to the finality that Lord Justice Carnworth identified there. And what the FTT is doing at paragraphs 330 to 328, from paragraph 320 to 328 of the decision, where it analyses what's happening over those periods of time, is precisely identifying that to be the case. So if you look, for example, at the various contingencies that the tribunal identifies through paragraphs 325 to 328 onwards, it was only, as it identifies on paragraph 331, on the 22nd of February 2011, that a transaction was presented to the Centrica board which requests the board to approve this transaction and to delegate the authority to enter into it. And it's at that point that the mechanics of implementation, we submit, begin. I think that's what I need to say about expenses management at this stage, if I may, my lords. My lords have the submission, my submission, that in it construing the provisions of section 1219 subsection 3, one must have regard to the purpose of the legislation. And in that regard, the purpose of the legislation is to be identified from the language that Parliament's used in its enactments. This is trite law. But in doing that, the context identified, the statutory context, must be borne in mind. And we submit that when it comes to construe section 1129 subsection 3, which we might turn up. One must proceed to identify, as my Lord Justice Singh identified at the outset of yesterday morning, a category of expenditure which is expenses of management, bearing in mind the test that we've looked at, but which is nevertheless of a capital nature. Now, the court has seen the views of the courts previously, before the introduction of this provision, which said that the category of expenditure which would constitute expenses of management, but nevertheless capital, would be thin. And in my submission, that's not, once one has properly construed the width of the category of expenditure that will constitute expenses of management, what that demonstrates is that there is little operation in the context of this particular code for the importation of the types of authority that my learned friend took you to, for reasons I'll develop.
I know I did put that to Mr. Ewart right at the beginning of yesterday's hearing, but might it be said that another way of looking at subsection 3 is that it's simply for the avoidance of doubt provision?
Well, it might well be. I mean, in a sense, that's one part of my answer as to what the scope of it is, my lord. In the sense, I would submit that the concession, I'm nervous about how I formulate this, but the concession that was made in Sun Life regarding, for example, the cost of the acquisition of the investments, they were expenditure on purchasing and selling investments. And insofar as that's the case, then subsection 3 is simply putting on a statutory footing a concession that was perhaps inevitable.
It seems unlikely. I mean, I don't want to take you out of order at all, but given the timing of when this amendment was introduced, which was bang in the middle of the litigation in Camas. And it wasn't an issue in Camas. As I understand it, my lord was in the case, but everyone was accepting that Lord Reed's test was essentially the correct test.
It was common ground, my lord.
Exactly.
Yeah.
So, but what wasn't common ground, very much not common ground, was whether capital expenses fell within the then legislative scheme at all. And we were shown the explanatory notes yesterday. We can see from the history and the timing of the amendment that what appears to have happened, according to the appellant at least, is that the revenue wanted to put on a statutory footing what they say they had always understood the legal position to be.
Well, my lord, I don't. I mean, I would accept that. That may be what the revenue intended to do by it, and it may also accept also the timing of it. It's obvious it was introduced, as it were, in response to the High Court judgment in Camas, because the notes tell us that.
But if that's right, that tends to suggest that the purpose of enacting this amendment was to do more than simply put on a statutory footing the concession which had been made in Sun Life.
And it may well be, and I can explain what that may be as well, my lord. But the other point to make is that, of course, in the context of Camas being argued before Mr. Justice Patton, what was not identified is the types of capital expenditure that would fall, what would constitute capital expenditure that would fall within any exclusion that would be put there in place. And indeed, the explanatory notes themselves don't take us really any further forward on that, because what one cannot get from the statutory language here in question is that section 1219 subsection 3a was intended to eliminate the ability to claim a management expense for the costs of investigation of the type that are now said to fall within that exclusion because of sergeant and heirs, for example.
I mean, in one sense, the sort of prior question is, can you get from this that Parliament will have had in mind the concept of capital, the concept of the distinction between capital and revenue, which had been used elsewhere for a very long period?
In a different context, my lord. I'm not sure that one can take it from the language here in question. I accept that the language is the same as the language that's included within the context of a trading business, but the entire nature of a trading business is fundamentally different. And in a sense, in the fiction of envisaging what is in Parliament's mind, the question arises as to what did it mean by expenses of a capital nature, having in mind the width of the category of expenses of management of investment businesses who, by their nature, will spend their days considering whether to buy, sell, hold, improve investments.
But there may be two slightly different questions. One is, did they have in mind the concept that had been used elsewhere? And two, supposing they did, nevertheless, maybe it works out slightly differently on the
How
facts.
they intended.
But it doesn't seem that unlikely that they reached down a concept that had been made use of elsewhere. I mean, it perhaps becomes clearer at the 2009 Act stage where there's an explicit linkage, and maybe at the 2009 stage that wasn't particularly thought to be affecting anything that was different from the 2004 stage.
I think that the danger with it, my lord, is that if one imagines a world in Camas, doesn't need to imagine it for the benefit of Justice Henderson here. I took the court to those statements that were made by Mr. Justice Patton and Lord Justice Carnworth, which, out of the side of a judicial statement, may come quite a large category of people of expenditure that nobody previously may have turned their minds to falling within this, and so one simply doesn't know quite what was intended by the legislative response to it. And indeed, that is why, before the FDT and the Upper Tribunal and in our skeleton, I kept pushing the point about whether or not it is HMRC's position that this provision was intended to reverse Camas. And my learned friend entirely fairly and squarely accepted yesterday that that was the Crown's position. But the hesitation, as it were, until we reach these points in that, to my mind, is perhaps indicative that possibly the answer is not quite as clear as might otherwise seem. But I come back to the point that what is not clear from a reading of this statute is that this was supposed to be a muscular cutting down or a slicing of everything that fell through Sun Life and Camas. In fact, it's quite an odd way of drafting it into it, if that was what was intended to do.
But is it not natural to assume, I mean, Parliament has chosen to deal with this issue in a single line, in very simple language. No deduction is allowed under this section for expenses of a capital nature. And to any tax lawyer, that immediately raises the spectre of all the law we all know about in relation to trading companies. And from many perspectives we've seen from looking at the history, a lot of it has been devoted to an attempt, allowing for differences in between the two types of companies, as an attempt to put them on commercially or economically a reasonably comparable footing. So from that perspective, ruling out capital expenditure in the same way as for trading companies seems an entirely natural thing for Parliament to wish to do, looking at it objectively, which we have to do, of course.
Of course, my Lord. I think there are two answers to that. The first is, I'm anxious not to keep banging the horse. I'm hesitant to accept that trading businesses and investment business, the same sorts of considerations may be in Parliament's mind regarding investment and trading businesses when it comes to capital assets. Because at one level of the very core daily business of an investment business is considering what to do with capital investments. And with respect to trading business, that's not its core business. It may have capital investments, and it may indeed carry out investment business, in which case it's inside these provisions in any event.
Well, yes, and it may make expenditure of a capital nature, in all sorts of contexts, but none of that is going to be allowable in computing its profits.
Exactly, but at the level at which capital expenditure is identified pursuant to the line of authorities that my learned friend identifies, it is very hard to see that that is not going to eliminate the core of the expenditure of and that may be the case.
Well, so be it.
Yes,
that's what Parliament wanted.
Yes.
I mean, it's not for us
My Lord.
to form a view as to what would or would not be a
absolutely
reasonable thing to do, as long as the language is clear.
Exactly, my Lord.
And the problem, perhaps the problem you had, is this language is so simple, in the sense that it's so clear in a tax context, it's very, very difficult to give it a whole lot of complicated qualifications of the type which your case seems to require.
Well, it doesn't, my Lord. I mean, in a sense, I don't ask for a complicated, or I don't ask the court to proceed by way of my answer to the question as to what is the category of capital expenditure which is excluded by that is in my submission more principled than that from HMRC, in the sense that we say that the category of expenses of management which are excluded by this are first of all the cost of the buying and selling of investments, and those which fall within the category on the wrong side of the Sun Lifeline, so the brokerage and fees that are part of the mechanics of implementation of buying and selling those assets. But secondly, it would also include expenditure on matters which were not part of, as it were, the management of the company. For example, the purchase of an office building. That's capital. We would accept that buying an office building is not part of the management of the investment business. Or rather, it's a capital cost of it.
Well, yeah, can we just be clear about that? Because I had thought, perhaps mistakenly, that was the kind of example that you would put forward as being something which would give practical effect to the amendment.
It is, yeah.
In 2004. In other words, it's a type of expense which would qualify as expenses of management,
Exactly.
but is a capital item.
My Lord, that's much better put than I put it. That's exactly our case on it. So those are two categories of of items which, on the face of the uncertainty from Sun Life, but also as a matter of general principle, would constitute expenses of management, but would fall within the exception identified in 1219 subsection 3.
So those are two specific categories, but that's not the overarching principle. What's the overarching principle to distinguish capital from revenue in this context?
Well, the overarching principle, my lord, would be to identify that the category of expenses which are of a capital nature, which are management expenses in this regard, is that category of expenses which are concerned with, as it were, capital assets of the business, buying and selling those. But of a particular form. It isn't all types of capital. It isn't all types of capital expenditure which fall within it.
So
what's the line?
I mean, what's the test?
Well, the test, first of all, is the buying and selling of the investments themselves. That is excluded by this. So the concession that was made by the Attorney General in Sun Life, that's on the wrong side of it. But also, expenditure of a capital nature on the framework of the business. Would fall on the wrong side of it. But in circumstances as where we have seen our business consist of holding of businesses all over, all of the non-US assets of the company, this may look, as it were, big beer to us, but this was the daily bread of what this company did for investments.
Mr. Rivet, I don't want to take you out of order, and I do mean that, but at some point, were you going to assist us about the case of Mallet?
Yes, my lord. I was going to come on to those now, actually.
Right.
So if the court is not with me on the capital income, on the importation of those capital and import income decisions, I start from this point. My learned friend took the court through a large number of cases on income and capital in the trading context, which established, it seemed to me, a number of different propositions. Expenditure that creates an enduring asset or an enduring advantage is not revenue expenditure. Expenditure which disposes of an onerous asset is not revenue expenditure. Expenditure which modifies an enduring asset is not revenue expenditure. If a capital expenditure has been identified, the fact that the transaction does not take place for some reason does not cause it to cease to be capital expenditure. If capital expenditure has been identified, the fact that expenditure repeats does not cause it to cease to be capital expenditure. In identifying capital expenditure, one looks not at whether the purpose was to benefit the trade, but what was the expenditure on. And the proposition that the question of income and capital is a question of law to be determined on the basis of the facts found by the FTT. What I will submit is that in these circumstances, on the findings of fact that was made by the tribunal, we do not have expenditure which creates an enduring asset or enduring advantage, which modifies an enduring asset to advantage, or which disposes of an onerous asset. What we have, properly analysed, is expenditure on advice in the context of a decision-making process. And that the authorities do not provide a mandate to look beyond what that expenditure was on, to say, oh, well, that decision-making process concerned a capital asset and capital transaction, and therefore it's automatically capital. And what my learned friend doesn't have is a bright line authority which demonstrates that in the context of an investment business, such as that here in question, the type of advice here in question is necessarily capital expenditure. When one looks in due course at the facts of ECC and Watkins, one can see that actually the expenditure is different to the type of expenditure here in question.
I do mean it when I say I don't want to take you over. Before we come to ECC, which to my mind is potentially a very important decision, can I just put to you the point I was going to suggest about Mallet? Is it convenient?
Yes, of course, my lord.
Yeah, that's tab 12 in volume 1. Because see, what I've been reflecting on is your fundamental submission, as I understand it, which is that the established case law from the last century on capital versus revenue expenditure was all decided in the context of trading companies.
Yes, ma'am.
And it may be that some insight is to be gained from what the Master of the Rolls said at page 162 of the bundle. I don't know. This is why I'm asking for your assistance on this. But you will recall that Lord Hanworth there points out against the first Hull punch that in that case the company is concerned to derive its profits from the sale of coal. Their business is not one of handling properties or buying and selling or dealing with properties. And I may be misunderstanding the point, but it might be said that because you're dealing with a trading company, you've got to start by characterizing correctly what its trading is, what its business is. And I think what you're saying is, but correct me if I've misunderstood, that you can't just transplant wholesale that body of case law to the context of an investment company whose very business is to buy and sell, quote, property, in the sense of the investments it holds, which could be a subsidiary company, for example. That's the structure we have in this case.
Exactly, my lord.
But where that gets one, I'm not sure, but I'd certainly like your assistance on that.
I mean, I think it gets it, in a sense, with respect, I think it is my answer to my Lord Justice Henderson's point, that whilst the language of the words that are used in subsection 3 of 1219 may be familiar to tax lawyers, there is not a case before today in which any court, before this case, in which the court has had cause to consider it in the context of these types of, in the context of a business of this type. But in a sense, even if it did, it would need to look at the particular facts of the business here in question. And as your lordship identifies, we might be in a different world, even, for example, on our own facts, if what we were talking about here was expenditure which was incurred by paying Ineco to take this troublesome set of businesses off our hands. But that wasn't what we were paying for here. What we were paying for was some very sophisticated financial and accountancy advice to work out what on earth we were going to do with this investment that we'd already made.
The trouble with your fundamental submission may be, as my lords I think have suggested, that would mean that although Parliament has enacted the same words in subsection 3A as it has done in, for example, section 53(1), and which have a very long history, and although Parliament can be presumed to have known of the case law on that formula, that in a sense, the courts have got to start again. we're going to have another century of case law, it might be said, on what the capital revenue distinction means in this context.
My lord, I can't escape from that. I accept that. That's my position.
Right.
That's absolutely my position, my lord. There's no shying away from that. That is our case.
Okay, thank you.
Which I suppose prompts the question, I mean, is that really a sensible intention to impute to Parliament? Particularly, I mean, the simplicity of the language is I think, important, partly because we're told this is, after all, we have it now in a tax law rewrite statute, which is meant to be intelligible to the general, well, at least some categories of general reader, and not to be too abstruse. And if you have a simple term used, as we do have here, simple language used, one comes back again to, if Parliament had intended something different from the interpretation of the same language in the context of section 53, wouldn't one expect it all to have been spelled out in a much more elaborate manner, instead of really setting up an elephant trap by using the same language with a different meaning?
Well, in a sense, it's an elephant trap that was foreseen by Lord Justice Calmworth, because he identified that in his judgment. The difficulty with it is, my lord, that you have to hold two separate things, presumably in mind, in ascertaining what Parliament intended. One is, one might equally say, if it were the intention of Parliament that it did not like the decision in Sun Life, and it did not like the decision as to the scope of what constitutes expenses of management in CAMAS as therefore articulated, there were a number of other ways in which it might equally have drafted this legislation to cut that down, rather than introducing with a sledgehammer authorities which end with the apotheosis of sergeant and heirs. Bearing in mind, if one looks at what the core content of the findings of fact that were made by our tribunal are regarding investment businesses, deciding what to do with investments, how to maximise the value of investments, how to realise value from investments. If you simply plonk the capital and income line of authorities into that, it's very difficult to see what on a daily basis an investment business does as not being covered by the same exclusion. I fully acknowledge the circularity of the point, my lord, but equally, I submit it's a point, I don't take the court to it because it gets at no one anywhere, but it's a point made by, in the Bramwell excerpt, you see being referred to in the Upper Tribunal and elsewhere. In order to make sense of this code, this provision has to be given some form of purposive construction, otherwise it vacates the relief of its for investment businesses.
Well, and I'm not convinced of that. I mean, you know, we've canvassed with both of you now various examples of types of expenditure which it looks as though the revenue would accept as being on revenue account, even with subsection 3 in its current form. If there are disputes about that, they'll have to be litigated in due course. But I mean, it doesn't seem to me at the moment to be a case where, you know, I can confidently say that the revenue's interpretation leaves expenses of management as a category without any content. I mean, if that were correct, that would be a very strong point. But at the moment, I'm not convinced that is right, whereas your explanation seems to be almost the opposite problem. It just gives it a really minuscule content, which is to deal with a point about a concession made in Sun Life, which, as far as I can see, has never been taken up by anyone since then as the subject for any really serious attempts to expand the scope of what's allowable and what isn't. And of a very small category of expenses which are really just part of the disposable costs as a matter of mechanics. And if that is all Parliament wanted to do, surely it could have done so much more economically and much more clearly, and not by enacting this very broad form of words, which, sorry, now I go in a circle, which repeats what everyone is used to in the context of a trading company.
My lord, the only point I would add, my point is not merely the Sun Life concession and the category that are, as it were, parts of the mechanics of selling goods. It's also the framework point that I made regarding the buildings.
Yes.
I'm done. If I might turn to, I should deal, if I may just quickly deal with the authorities that my learned friend relies upon. Deal with them quite quickly. Could we turn to ECC, please? The first point I think I'm going to start with is to just deal with the question as to what the expenditure in question here was on. My learned friend said that the cost in question were the cost of legal expenses, I think mainly in dealing with planning inquiries to obtain planning permission. And he said that at page 80, 5 through 8. And then he said on page 88, of course, the expenditure we're dealing here with not expenditure on the fees, but expenditure on the legal fees of the lawyers who were carrying out the, no doubt, advice was given in the process, but that wasn't the point. The point was what it was paid for. It was paid with a view to getting planning permission. And that, in my submission, is not borne out by a close reading of the facts of this case, and is also inconsistent with the findings of fact that were made by our tribunal, which is that the fees were paid for advice. We start with the case stated on page 311. Paragraph 2 tells us that the expenditure was incurred by the company in connection with applications for planning permission to extract sand. The precise nature of that becomes slightly harder to identify when you dig into the case stated a little bit further. If we look at paragraph 6.2 on page 314, you'll see legal and professional charges described there.
Sorry, which page?
Sorry, my lord, 314.
Paragraph.
Subsection 6.2. It's below the second hole punch,
Okay.
just between H and J. You can see the entry in the accounts, the P&L accounts, and I think it cross-references back to paragraph 21, which is a little bit further up the page. Annexed to the case was a list of expenses incurred by the company in connection with the planning applications relating to Black Hill, Colleton Rally, Straightgate Farm and Lowlands Farm, and in connection with the deed of variation up to the time of the refusal of planning permission. The list contained an explanation of each individual item. The total expenditure for the years was 26,000. The difficulty with it is we don't have in the case stated, and I don't think it's in the STC itself, precisely what it was that expenditure was broken down into. What we do know, though, is we know the point in time at which it was incurred. And you get that from paragraph 21 and also from 62, because you see the entry into the books for the period of point in time. So, bearing in mind the timing at which this expenditure is incurred, I submit it's a pretty fair inference that what was going on here was not information that was not legal advice or legal professional expenses that were going on in 1965 or the prior applications in 97. It relates to applications that look as if they've already been made. And you can get some support from that, I think, from the earlier points in the case stated. If you look at paragraph 13, following the submission of the 3 applications, a lengthy process of consultation took place between the company and representatives of various local authorities, and the company also attended a meeting with representatives of local authorities at which the proposals were explained in detail and questions answered. And you get a bit more of that from 14 to 17, where there's mention of chartered consulting engineers. Now, when we come to look at the judgments, if you look at 327C, what his lordship describes the expenditure as being is expenditure in surveying, legal and similar costs and expenses.
Sorry,
Sorry, my lord.
Oh, yes, I see, yes.
See, and if one turns back to the head note, not that that's a particularly satisfactory guide, the writer of the head note summarises the expenditure at paragraph E as being sums incurred on preparing and presenting its planning applications.
So that would have to be between October 67 and September 69.
I think that's what. I think it's later. But the point I'm making, my lord, is that whatever this is, the inference that you can draw, so far as one is able to, as to what the expenditure, what the legal fees and expenses were, is very different to the advice that was being procured in consideration for the expense here in question.
Well, I'm sorry to
My lord.
to labour this, but it may be important. In my experience of the way in which the planning process often works, certainly if you have any kind of sophisticated development proposal, which will often be by a large company, there'll be several stages. Long before you get to the stage of submitting an actual planning application, you will want to have obtained professional advice from a number of sources about what the prospects are going to be.
Exactly.
Because nobody wants to waste their time and money on something which is going to be fruitless. And what I don't know at the moment, speaking for myself, is when Mr. Justice Brightman states the principle apparently as widely as he does, whether he had in mind those kinds of preliminary stages. Because very typically, what you'll have is housing development is to go up somewhere on the periphery of existing urban development.
Yeah.
There may well be 3 different sites which are potential candidates. And the developer will want to have the best advice about where it's really going to be viable. Or am I going to find that if I stick in a planning application at site A, somebody's going to turn around and tell me that there's a huge flood risk there, which is going to mean it's going to be turned down. So long before you go through the formal process of a planning application, which no doubt itself will incur some professional costs, like lawyers' costs, you will have incurred a lot of other professional fees. But I mean, can you help me on that?
Well, my lord, that's exactly the point. In 106 agreements, you might be as a developer thinking, goodness, what's it going to cost me in terms of the ransom to the community to build this? All of these things will be advice. But in my submission, although it is not clearly said by Mr. Justice Brightman, when one actually looks at the case stated and the facts that he was called upon to decide, there were costs which were after the application was made. So it wasn't that category of advice. And in our circumstances, I submit, the analogue is with that former category of advice of deciding not what to do and inputting into it, not with this type of advice, which is, in my submission, on the implementation side of the line. It's after the application's been made.
Just as to what you're dealing with, and I don't think this answers your question at all. So going back to 582, we see at subparagraph 11 that the applications were submitted on February 67. So that's too early to be relevant to this purpose, isn't it?
Yeah. So the expenditure appears later.
And then we see 13, following the submission of the 3 applications, a lengthy process of consultation took place between the company and representatives of local authorities, and the company also attended a meeting and then there was a calling in and a public inquiry which lasted 18 working days, followed by an inspection of the sites and so on. So whatever they were, presumably the expenses are likely to have related to that stage.
Well, my lord,
Those
that's my I think that's what it's saying. But in that would be a different quality of expenditure to the expenditure on the advice that my Lord Justice Singh was talking about, and in my submission is of a very different quality to the nature of the advice which was the subject of the expenditure in my case. I hope that satisfactorily answers your lordship's. It's a factual distinction. In a sense, it may also give rise to a wider point that there is a danger in extracting too clear a principle in cases that are decided on the particular facts that the judge is called upon to decide. What I don't think one can take fairly from the report is any indication that what Mr. Justice Brightman was deciding was a principle that would apply to, as it were, advice absent all of these points.
Yes, page 326, letter H. Well, G to H really appears to be, it may or may not be right, but it appears to be where one finds a statement of principle. Because what's being said is that the planning permission itself can be regarded as an intangible asset of a capital nature, and that from that premise is drawn the conclusion, if that is right, money expended in seeking to acquire such an asset must equally be expenditure of a capital nature. Now, read broadly, that formula appears to be capable of including money expended, for example, on early professional advice about flood risks and things of that sort. But you say, read in its context and on the facts as found in the special commissioner's case stated, one never reads words in a judgment out of context. In order to find the ratio of the case, you always have to understand what the facts were, what is actually being decided. And I think your submission is whether or not it's correct in relation to what it actually decides. It's certainly not saying anything about the earlier kinds of expenditure.
No, my lord, and particularly not, and precisely, my lord, coupled with the fact that in the context of our case, if that naked principle is taken to its extremity, I fall back into my circle with Lord Justice Henderson. That could, I mean, that's our everyday life as an investment business. Should we buy this business or should we not?
Well, we won't go over that.
Yes, sorry.
I think the fundamental point you have to meet is Mr. Ewart's submission that in June 2009 there had been a decision in principle, sometimes called a strategic decision. We've got to get rid of this loss-making business. So he says the advice which is then obtained for the following year and a bit is about implementing that decision. How do we dispose of this?
But even if that were the case, my lord, by the analogy with, in a sense, the danger, there's possibly a danger with trying to draw an analogy between a planning process and the divesting or the exiting of a commercial position in relation to an asset, and particularly of this sort of complexity. Because, as we know from this, our case is very different to Camas, where there's a linear process once you fire the pin. A decision in the abstract, we don't want to be in this market anymore, is a radically different decision from, okay, I've taken all the advice about plan commission, this is the one we're going to go for, let's implement it. The analogue, I would submit, in our case, would be the point in time at which we have, as it were, heads of terms agreed with an echo, and we go into the contractual, we have contractual rights that are created against an echo regarding the exit of it. I'm very conscious of the time, my
Yes.
lord.
Sorry, just a moment. I think this is a point for you rather than against you.
Oh, thank you, my lord.
Am I right in understanding really what you're warning us against is what Lord Wilberforce called the formula trap in Tucker?
Yes, exactly.
It's a sentence before that mysterious asymptotically.
Yeah, exactly. And if and insofar as there may be formulas or principles that may be useful, it's very dangerous to simply transplant them from a different statutory context to different businesses here.
Well, yes, I mean, speaking for myself, that's obviously something we need to be very much aware of. But where I thought would help us end up,
So just
begin to know.
just trying to pin it down a little. So you say there are two potential distinctions. Probably don't quite say this, but I'm just trying it out. One is you're dealing with an earlier stage in this case. You haven't got as far as anything very definite. And the other, and I'm not quite sure where you take this one, is a distinction between advice and something different.
Well, you can see it actually in Mitchells and Butler as well from this morning. I mean, what the expenditure in Mitchells and Butler is concerned, there are different sorts of professional expenditure that might be incurred. For example, and indeed this is a point that's obviously live in this case, expenditure for De Brouw to enter into negotiations and draft the terms of a contract for sale and advice on what the impact of those contracts for sale may be is a radically different thing from advice from Deutsche Bank about how you might economically get value out of an investment. And the type of advice that was secured as a result of the fee here in question on the findings that were made by the FDT is at a level of abstraction which is, in a sense, even before the point at which you get to Lord Justice Singh's example of advice about how to get a planning permission and what the cost of it may be. It's should I even get into property business? And the fact that one puts the epithet strategic decision in front of it is a misnomer, because when one looks at what's meant by that, it's a different thing.
Just relating back to ECC for a moment, as you say, we don't get a detailed explanation of what we were dealing with. But the fees were incurred in the context of negotiations with the local authority and then a planning inquiry, seemingly. Plainly, that would have included things that were not advice to the company, but were rather doing things for the company in relation to something
Representing
else. But the chances are that they would have included advice as well. In such a case, do you have to apportion?
Well, one may or may not, but it depends. Maybe the example is, again, perhaps back to De Brouw. That De Brouw, as well as physically putting four associates up till 4 o'clock in the morning drafting the terms of the sale agreement, no doubt the partner was saying, if we put this clause in, it'll work this way, it'll work that way, the other way. But that sort of advice, one has to look at the content of the advice as well. The content of the advice, we don't know what the advice was in ECC and what case. But on the assumption that it is advice that occurs after the planning application has been made, as part of the consultation process, it's about how to successfully bring that outcome, that the process the trigger's already been pulled. Ours is nowhere near that yet, because all we've really decided upon is an ambition to divest ourselves of this business. And I make the same point. I'm just very conscious about my learned friend's reply in relation to Mitchells and Butler. That when one looks at the facts of that, for your notes, my lords, if you look at page 294, little h in due course, in my submission, a fair characterisation of what's going on there is the legal cost of representation. My lord, that was a very long answer to a short question. I'm sorry.
No, that's helpful. Thank you.
Just to be clear, if I may, and I'm sorry to take up time
No,
answers to you, but I want to be absolutely clear. This last part of your submissions, as I understand it, would equally apply if we were dealing with a trading company. this bit doesn't depend on your earlier submissions
No,
about the investment.
no, it doesn't, my lord. I'm assuming at this part of my submissions that you're against me,
Yeah.
and that you import into these provisions the question, the historic case law. In those circumstances, I would say that that's still not fatal to my case, my lord, and the facts that were found. My lords, thank you, unless I can help you further.
Thank you very much. Mr. Hewitt.
Seems that this appeal is probably more interesting than you thought at the beginning, because it's taken us the whole of the 2 days. Can I just start with ECC, since we have it out and you've been discussing it? Can I make it clear? My understanding of what was happening in ECC is exactly the same as my learned friend. I'd always assumed that the legal expenses and the professional expenses that we're talking about were those in actually obtaining the planning permission. In other words, after the application had been made, in dealing with the inquiry, etc. My point about this case is a number of points. One is, what it shows is we're not just when we talk about the costs of or expenses on acquiring an asset or disposing of an asset, you're not just talking about direct costs that you pay to acquire the asset or dispose of it. You are talking about things that you have to expend in order to acquire it or dispose of it. So professional fees in this case, it's not just, as I think Lord Justice Singh was suggesting, the fee that you pay or whatever. It's more than that, much more than that. The other point I was making was, as part, inevitably, if you're representing a client in any court proceedings or inquiry, what you're doing involves advice. I mean, it would involve, for instance, the client would want to know how to present the case, what evidence to call. You're advising them in a sense. I mean, you're presenting the case, but it all involves advice. So the fact that advice is involved doesn't disqualify the expenditure. That's not the touchstone. I agree, though, that the point was that there was an application that had been made, so it was directly on acquiring the planning permission. Now, of course, we say that in this case, the analogue is the decision to sell, taken in 2009, but it wasn't just a decision to sell, which was obviously publicised and in the accounts, but at the same time they engaged exactly the kind of professionals that you would expect to engage if you're embarking on a sales process, i.e. Deutsche Bank, to find purchasers, to deal with the purchasers, obviously to give advice as to what price to pay, etc. But that's all part of the sales process. And then PwC, well, that's slightly unusual because of the nature of the asset, but they were engaged, as we know, to provide the vendor disclosure, the vendor due diligence. So we say that's exactly analogous to this situation. My learned friend is trying to paint it as being all advice, and at the earlier stage, and our submission is no, this is a sales process. Indeed, we saw in one of the paragraphs that you looked at earlier, I think, that Centrica themselves described it as a sales process because they talked about pausing the sales process. If you remember, in order for because the local people were busy doing the accounts, and then, so there's a period in which they didn't have time, they didn't have the availability to deal with it. So they said they paused the sales process. But we would submit that's a proper characterisation of what happened from July 2009. But there was a sales process going on, which involves both activity by Deutsche Bank and actually doing things, but also advice. I'll come back to that in a moment. On mallet, my lord, I think what the Master of the Rolls was saying in that passage that you drew attention to, he was actually making quite a simple point, clearing the ground, if you like. He was saying this company does not deal in land or anything like that. If it had been dealing in land, of course, these would have been revenue transactions. But the point he's making is the nature of its trade was something different, and these are capital transactions we're dealing with. And that was the point he was making in that passage. You just pick it up. It was a very, if you like, very basic point.
So, but you accept that the same expenditure could, in fact, qualify as revenue expenses.
I'm sorry.
You accept, therefore, I think, that the same expenditure could qualify as revenue expenses, depending on the nature of the company's business.
If the company was selling trading stock, then of course expenses involved engaged with that would be revenue, because it's trade is to buy and sell trading stock. Of course, yeah. Oh, it's basic. It's fundamental to all of this. In all the cases, the asset in question is a capital asset of the business, whether it's a trading company or investment.
But I think the fundamental point Mr. Rivet is making is that it's not possible simply to transplant statements which have been made in the context of ordinary trading companies into the context of investment companies, where their core business, as he calls it, is the buying and selling of properties.
Well, I would dispute that. The core business of an investment company is to hold investments. Of course, they will buy and sell them from time to time. But the core business of an investment company is holding the investments and for income.
And if it begins buying and selling too much, it's always a danger of
It would
the
become...
inspector of taxes knocking on the door and saying, actually, it's a trade you're carrying on.
Yes. Of course, sometimes that's beneficial.
Oh, indeed.
Yes. But it's right. If you get to the stage of buying and selling as a trader, everything changes, because then you would be dealing in land or whatever. And I thought that was just what the Master of the Rolls was saying, that we've got to be clear here that this company's trade is this, and these are not trading stock or anything like that, they're capital assets. I think my learned friend started by making the statement that's been made a number of times in some of in the tribunal, that there's a danger that all costs concerned with a capital asset would be capital, and therefore an investment company would have no deductible management expenses. But of course, when you look at the cases on capital revenue, that's not the test or the approach. It's not the question. It's not the case that all costs concerned with a capital asset are capital. It's a much more precise test than that. I hoped I showed you that what Lord Wilberforce was explaining in Tucker was, it's basically the costs of acquisition, the costs of disposal, the costs of improvement of a capital asset, an identifiable asset, or you then come on to the extension, things which are not perhaps recognisable assets, but are sufficiently of an enduring quality, give a sufficiently enduring advantage that they would be treated as capital assets. That's the extension. But it's not the case that you would say anything you do in relation to a capital asset or in connection with it. And I would repeat that there are plenty of management expenses. I said wages, rent, which is quite clearly a revenue expense. I was trying to say, but the case law, if you remember what was said in the House of Lords, they said conceptually there may be some interesting difficulties about the difference between a premium for a one-year lease and rent. But the fact is that it is the law that rent is a revenue deduction. So I wouldn't say there's any doubt about that. Our wages. And there's lots of other items of repairs and maintenance, if you've got buildings, administrative costs, for instance, costs in relation to, say you were hiring space in the cloud for keeping your records, that would be a revenue expense. So there's plenty of revenue expenses. And of course, it's not just trading companies. We've been saying it's trading companies, not just trading companies up until now, up until 2004, who had the capital bar, as I pointed out. Property property companies, who were investment companies, had the capital bar. Because Parliament, in its wisdom, thought that they could be treated, they could be taxed in the same way as traders. Which rather gives the lie to the thought, which I think my learned friend had, that it was impossible for an investment company to be dealt with in the same way as a trading company in this regard. Parliament clearly didn't think that in relation to property companies, which are classic investment companies. Just a few short points on the legislation. I think you may have picked these up. My learned friend drew attention to the referable to point, which is, I think Lord Justice Henderson said, was to do with the timing. He also drew attention to in respect of so much. I think when you look at that is to do with the hybrid kind of company case. So you've got to decide how much of it is in respect of the investment business as opposed to, say, the trading business. Lennifer also made the point that this was different from trading because it was a provision that gave relief, but then was an exception to the relief in some way. But in fact, the position really in trading company is the same. You're entitled to the relief, and then there are provisions which take it away. And this is one of them. The capital provision in trading companies says you can get relief, which you would otherwise get under other provisions. The starting point with trading companies is profits on GAAP principles, generally accepted accounting principles, and then there are a whole list of statutory provisions which then say you can't get a deduction for these things, and one of them is capital. Now that is not exactly how it's not exactly how the management expenses provisions work. However, looking at the provisions that my learned friend took you to on the timing, if you like, accounts, when you work through these, you find that if the expense wasn't deductible according to generally accepted accounting principles, there is no period for which you can actually claim it, because you have to claim it in a period in which it would be deductible in accounts drawn up on generally accepted accounting principles. So actually, although by a different route, you end up with the same result as for trading companies, I would suggest. There really isn't much difference in principle between the two in that respect. And then we have the point that this doesn't allow taxation of the economic profit. Well, I mean, that just begs the question as to what Parliament thought was the appropriate profit. So when my learned friend enunciated his test, he referred to two things. I think one was cost of acquisition of investments and the associated costs that were referred to in Sun Life, and also the cost of acquisition of, say, headquarters building. But the problem with that is, in my submission, none of these would be expensive management in the first place.
Why not the acquisition of the headquarters?
Well, because that would be just as much a cost of acquisition as the cost of acquisition of the investment.
But it's not cost of acquisition of the investment.
Yes, but it's a cost of acquisition, which would be a general. I mean, generally, you wouldn't have the cost of acquisition of an asset as being a capital asset as being an asset like that as being management expense.
Why not? As a matter of principle. If the salary you pay your workers in that building is an expense of management, then why isn't having a building for them to work in an expense of management?
Yes, well, it does seem strange that the cost of the investments isn't as expense of management, but the cost of the building is. Maybe you're right. In which case it would remove that if that were the case. I'm not aware that companies would be claiming the cost of the buildings as an expense of management. That would be quite a radical departure, but certainly they can't do it anymore. Yeah, yes. Would be quite strange if they were. Be quite a large expense of management
But your fundamental submission is that to make sense of what Parliament has done in 2004, the natural way to read it is it's put in a one-line amendment which should be interpreted the same way as those words would be interpreted elsewhere in the same act.
Absolutely. Yeah, that's our fundamental point. There's nothing in the legislation itself or in the explanatory notes or any background documents which indicate that anything else was intended, and certainly not anything as specific as my learned friend suggests. That's exactly our simple point, is capital means capital. So then turning briefly to the application of that, as my learned friend says, assuming that we're right about that. I think I've already indicated briefly what our case here is. Looking at the findings of all the findings of fact, you've got the initiation of a sales process. You've got findings as to what the Deutsche Bank and PwC were engaged to do. You've got a finding that they did what they were engaged to do, which is paragraph 125, and that's what they were paid for. And it doesn't help in this analysis then to point to a paragraph where the tribunal talks first about advice, but then I think, as Lord Justice Henderson points out, goes on to talk about the other things which they were doing. That's not a finding of fact that the only thing that was being provided was advice. If it was, it would be contradicting the findings of fact that they made previously. You do have to read the decision as a whole. You can't simply pick out a paragraph and say, well, look, this is what the tribunal found as a fact. They found that they were to ignore all the other things that were being done and simply categorise it as advice. Insofar as there was advice, which clearly there would have been, there was, we would say that was all simply part of the sales process. And would not be unusual in any sales process, particularly one that didn't go well, that there would be a certain amount of advice. One can perhaps test it this way: if you carry out this thought experiment, supposing everything had happened in the same way, they had decided to sell, they had instructed the advisors. After a few months, Deutsche had found a purchaser who wanted to buy the company, which is what they were trying to sell initially. So everything went smoothly. They went through the process of a number of months, and eventually, after 6 months or so, they sold the company. It was a smooth process. In other words, it's the same engagement, the same services. Deutsche would get their €2.5 million. Would that make a difference to the analysis? Now, we would say it can't possibly make a difference, that the process went through smoothly rather than was bumpy. But if you think about that, why on earth would that not be capital expenditure? Their job was to find purchasers. They found a purchaser, negotiated an acceptable price, and the property was sold. All the rest of the bumpy road just illustrates that this was a difficult sale process. It doesn't change the nature of what the expenditure was on. That would be my submission. And we would submit, even in a trading company case, there would not be any doubt that the expenditure on agents which were instructed to sell a capital asset, say a factory or a headquarters building, would be part of the costs of sale, costs of the disposal, and would be capital rather than revenue expenses. I think my learned friend accepted that on this part of the case. When you get to this stage, he has to say the position would be the same for trading companies. So he's really inviting you to essentially change the law in relation to trading companies. So we say fundamentally, none of the facts in relation to the sales process in this case were in any way unique or unusual, in the sense that they would occur in other sales processes. They didn't have a buyer at the start of the process. Well, that's always going to be the case. They wouldn't sell at any price. Well, again, hard to imagine many sellers who are going to sell at any price. We'd have to consider how precisely to sell. Well, that often is the case. Sometimes is the case. Sorry, sometimes is the case. Even in the more sort of straightforward examples of property sales, as probably Lord Justice Henderson knows, in the past certainly it was very advantageous sometimes to sell a property in a company. So you sell the company owning the property. There were reasons for that, tax reasons basically often. In fact, now there are tax reasons why it's often better not to have the company, strangely. But those will all be a matter in a sale that would be negotiated between the seller and the purchaser. There's also there might be matters about covenants or easements or whatever.
Well, absolutely. I mean, inquiries before contract can throw up all sorts of problems. You might suddenly discover you've got asbestos or
Exactly, yes.
things that need clearing up, environmental issues, planning permission.
Yeah, you might need advice on that.
And they might take a very long time to sort out and need a lot of expert advice.
Yes, or you might have, say, a landed estate, and you might have decisions as to how to sell it in parcels, or to sell it all together, or sell it leasehold or freehold, or whatever. There's all sorts of decisions that have to be made in the sales process. But those would all be part of the sales process. If you've decided to sell, you're instructing people to do it. We would say these are all capital items. I don't think, as far as expenses of management are concerned, I think you've got my submissions on that. I think it really depends on an interpretation of what Lord Justice Carnwath said in Camas. But I just repeat, whatever the answer is to that, we would say the capital question is quite conceptually distinct. Can I just say something about the remitter? I would suggest that the position is this, as regards that. If you were to decide that all of the Debro expenditure, as well as everything else, is capital, then there would be no need to remit the matter to the First Tier Tribunal, obviously. Equally, if you were to decide that none of the Debro expenditure was management expenses, again, there would be no need to remit it. But if you didn't come to either of those conclusions, then I think the position would be the remitter would stand.
Presumably, the question of actually making progress on the remitter has been put on hold pending this appeal. So
I think so, yeah. Yes, nothing's happened.
No.
So I think those are my submissions unless you...
Thank you very much, Mr. Stewart. Well, you won't be surprised to know that we won't be giving judgment here and now. So we will reserve our judgments. As has now become customary, we would expect them to be handed down remotely rather than in a courtroom. Even were there a hand down in a courtroom, there would obviously be no need for anyone to attend. You will be provided with the judgments in draft for you to correct our typing and other similar things, but not to re-argue the case. And we'd be grateful if you would seek in advance of the hand down to agree an order. If there are any points on which you disagree, we'd be grateful for short written submissions, and we'd expect to deal with the points in the order that we make. I think you have provided a list of email addresses to which the draft judgments should be sent. I'm sure that you will have very much in mind anyway the remarks of this court recently in the Counsel General for Wales case as to the importance of maintaining the confidentiality, and I would once again stress that point. But with thanks to you all for very interesting and stimulating submissions, we'll leave it there.
Thank you very much. Interesting.